Good morning, ma'am. You're Crystal Calvillo?
Yes, ma'am.
And Ms. Calvillo was previously in court and cause number 24, DCCR 2456, entered a plea of guilty to the state jail felony offensive theft of property. I've received that pre-sentence report. Any additions or corrections to that report?
No, not from the state. No.
All right, ma'am, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years.
Yes.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you will never have that felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and then you could be sentenced anywhere in the range of punishment, which is up to 2 years at a state jail prison. Do you understand?
Yes.
And there's no restitution, correct?
No.
Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you up to her desk when she's ready to go over all of your paperwork.
Thank you, ma'am.
Good luck to you, ma'am. Thank you, sir.
Thank you.
Thanks. Ms. Holmes,
Yes, sir.
you've got a sentencing on Cameron Gutierrez.
Yes, sir.
Sentencing on Cameron Gutierrez. Good morning. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez was previously in court and entered a plea of guilty to evading arrest or detention with the use of a vehicle in clause number 25 DCCR 0325. I've received that pre-sentence report. Have you both had an opportunity to review it?
Yes, sir.
Yes, sir.
Any additions or corrections?
And from the defense.
Not from the state.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years.
Yes.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation.
Yes, ma'am.
If you do that, this is a great opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end of the probation period, the case will be dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, which would make you a convicted felon, and sentenced to prison for anywhere in that punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork.
Okay.
Good luck to you, sir. Thank you.
Thank you.
Mr. Kelly. I lost Mr. Kelly. Mr. Mitchell, you've got John Van Wright,
Present.
2 cases.
Yes, sir.
Good morning.
Good morning. How are you doing?
Good, how are you?
Oh, I can't complain.
It's Monday. Nobody would listen if we complain anyway, right?
Moving for forward. Be here though.
That's right. Good morning, sir. You are John Van Wright, and this is 24 DCCR 2485 and 15 23582. What is the announcement?
As far as the NTRP, it would be not true, Judge.
Okay.
I feel that you know.
I think we'll just prove up the MTRP first, Judge.
Okay, so let's do this then. Let me get that pulled up. We'll go through that entire motion, and then we'll get an updated report and set it for sentencing. Mr. Van Wright, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. And will he waive the formal reading of the motion?
Yes, Judge.
Mr. Van Wright, in cause number 1523582, I have a motion to revoke your community supervision. Shows that you were placed on probation July 28th of 2020 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 10-year term in prison, but it was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of injury to a child, elderly, or disabled individual November 14th of 2024. And is that true or not true? All right, did you enter your plea of not true to count 1 freely and voluntarily? All right, then I'm going to enter that plea of not true on that count. I'm going to reset the case for sentencing hearing. About how long do you anticipate?
I want to know more than that.
About an hour or so, so we could do it maybe at the end of a docket. Sure. So we'll set it for 11, probably on a Monday, just at the end of one of these dockets, unless I can find a time when we're not in trial on another week.
Okay.
And that'll give y'all time for any evidence.
Let me know, or have Kelly or somebody let me know so we can get witnesses.
We'll do it. She'll be back tomorrow, and we'll get that set in the next couple of days. If I can get an updated pre-sentence report, that would be great as well. And then we'll see y'all back at sentencing. All right.
Good, Judge.
Thank you. We need to get this print, please. Yeah, make a note for Kelly, though, that it needs a hearing about 1 hour. We probably can do it on a Monday unless we find another day.
Yeah, I think this was Judge.
Yes, thank you. Mr. Rennick, you have a sentencing on Alexandria Bledsoe.
Yes, Your Honor, she's correct.
Sentencing on Alexandria Bledsoe. Good, how are you doing? Thank you. Good morning. Are you Alexandria Bledsoe? And this is 25 DCCR 0004. Ms. Bledsoe was previously in court and entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, sir.
Any additions or
Only
corrections?
one minor thing my client would bring up. The name of her employer was Sigma, correct, or Sigma? Sigma, it was listed as Sigma, and she was just worried that that might be an
Okay.
issue. I told her not to worry
Don't
about
worry
it,
about
but
that.
she wanted to bring it to the court's attention.
Okay, thank you very much. Anything else? All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include completing an intensive parenting class. If you haven't already done that through CPS, there's going to be something through probation that you're going to need to do, obviously. If you do everything that you're supposed to on this probation and follow all of the rules and conditions, then this is an excellent opportunity because you do not have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Okay. Obviously, I would like to think that this was a huge wake-up call because this could have been very, very bad. And so take care of your child, take care of the classes, make sure you make all of the right decisions when it comes to that, and you shouldn't have any issue. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Rennick. And Mr. Rennick, you also have Patrick Gallagher sentencing, 24 DCCR 2422.
Yes, Your Honor.
Sentencing. Patrick Gallagher.
He's also a, I have one other after that.
Good morning, sir. You're Patrick Gallagher. And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
No, Ms. Mitchell.
I didn't see any, Your Honor.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember.
4 days.
4 days.
That's what it looks like to me. It expired. Community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I drink and I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough. Are you still working
Yes, ma'am.
at Exxon?
Judge, there is one issue I was bringing up whenever.
Go ahead.
I spoke to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as if the court was willing to, he had dates that he was not working to do the 10 days.
Okay.
That is something I would bring to court.
Sure.
Oh, you weren't quick enough. You were quick though. Okay.
It was the highlighted dates is when he is not working that he was asking the court to. I know he knows it's a big ask, but
Well, I mean, I don't know. It kind of is. It kind of isn't. Typically, I let people who are working do it on weekends. This is just how the weekends
I have no
for his
issue
weekends.
with the erratic nature.
Here's the more, I guess, the part that's going to be potentially something that you're going to have to really figure out with your job schedule, and there's not going to be any excuses, is that you're going to have to enter and successfully complete the JCDI program. It is an intensive outpatient program. You're not the only patient that will have to do it on this type of schedule, but you're going to get started on that immediately without any mess ups, because if so, you're right back in here and you're going to be looking at going to prison. Do you understand?
Thank you.
So what I'm going to do then, Mr. Gallagher, is find that you entered your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't,
no judge.
the bond, it wasn't a condition. Well, because the blood came back with positive of Delta 8 THC. I'm sorry.
Correct.
Yeah. Are you doing anything like that still?
No, ma'am. I work for ExxonMobil.
Well, I mean, did you work for them when you,
I did, but I had a vape that I didn't know was there, so that's history.
you're 52 years old and you're using a vape that you don't know what's in it? Do you want me to buy that?
You don't have to do it.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right. I'm going to do this. Going to find that you entered your plea of guilty freely and voluntarily. find sufficient evidence to find you guilty, and at this time follow your agreement, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, actually, I'm not going to follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think, warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway. So it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time. That is going to be on the date starting. I'm going to attach, I'll give you this copy as well, but so like where it says 9 nights, you work that night of the night. So you'll start on October 10th. I want you to turn yourself in October 10th at 6 p.m. And then you'll spend the 10th and the 11th, and they'll release you on the 12th. Okay? And then when you work days, what time do you get off?
4 o'clock.
4 o'clock p.m.?
Well, depends on when I leave. So it could be 4 to 4:30 to 5.
Okay. So the next time is going to be, since you're working days on the 16th, you're going to go at 6 p.m. on the 16th.
Okay.
And then you'll spend that night, the 17th, and get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
And we're so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay. If it doesn't say days or nights on this calendar, does it mean you're off?
Yes, ma'am.
Okay. So that second one in October, you're going to go, we're going to get this done.
Okay.
Because that's your long days off. So we're going to get that week done. So you're going to go in on the 16th. And you're going to get out on the 23rd. So that gives you one overnight, the 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days. So that's 9.
So you're saying go in on the 16th when I get off work that day?
Mm-hmm.
Okay.
And we're just missing 1 day.
There's 7 November on the back of it there.
No, we're getting this will be done in December. So you're going to then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day, and I'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. You need to have a seat here in the courtroom and wait for probation to call you.
The courtroom became tense when Judge West confronted a defendant over an explanation that she clearly wasn't willing to accept. The defendant was given an opportunity to explain his position, but instead of providing a response that addressed the court's concerns, he offered an explanation that left the judge questioning whether he fully understood the seriousness of the situation. Judge West listened carefully. came the response that immediately changed the atmosphere in the courtroom. That's something a teenager would say. The judge's comment was direct, but the larger issue was the defendant's explanation. The court was not simply looking for an excuse. Judge West needed a clear and meaningful response to the legal issues before the court. The defendant continued trying to explain his position, but the judge made it clear that the courtroom was not the place for excuses or arguments that avoided the central issue. This became an important moment in the hearing because judges have to determine whether defendants understand the consequences of their actions and whether they are taking the proceedings seriously. The prosecution also had an opportunity to address the defendant's explanation. From the state's perspective, the court needed to consider the evidence and the circumstances of the case rather than relying solely on what the defendant said during the hearing.